Well, good afternoon. I'm Chris Mackay and I'm a partner in the construction and projects team at Burness Paull. I'm joined today by 5 of my colleagues, Kirstin Beattie, Chris Horsley, Richard Farndale, Kate Primrose and Erica Dickson. So a warm welcome to our final webinar in our construction winter webinar series. So today what we're going to do is have a whirlwind roundup of the top 5 cases of 2020. Let's get started. The cases we're going to cover today, 4 of them are English law cases, but of course they're in the main relevant to Scottish projects and disputes. So firstly, Kirstin's going to cover the Energy Works against MW case, which was about an energy for waste project under the ICME Red Book at main contract level and Yellow Book at subcontract level. The project didn't go well and the main contract was terminated. So the case considers how post-termination, assignation and novation of rights can affect a party's rights to sue another. Secondly, Chris is going to cover the Taka v Rockrose case. I thought this was going to be a case about gin, because I'm quite a fan of Rockrose gin in Thurso, but it turns out the case is about termination of Marathon Oil's rights to operate the Braes oil field in the North Sea, and Rockrose is another American oil gas company which took over Marathon's interests. It's about the important topic of implied terms, and the case considered to what extent there should be implied a qualification on the rights of other joint operators to exit Marathon. Thirdly, Richard's going to cover the Entertain Video against Sony case. Now, fire and explosions have a good track record of developing the law, and here the case concerns the whole Sony distribution warehouse in Enfield, London, being torched in the London riots after a police shooting. The judgment revisits the 1854 Hadley v Baxendale case regarding consequential loss and considers what losses could be recovered against Sony, who were in breach of contract in not better protecting the warehouse from attack. Fourth, we're going to hear from Kate, and she's going to speak about the case Rochford Construction against Killen Construction. And it's a payment dispute, and it revisits the application of the Construction Act, sections 109 and 110, in terms of both stage payments and due dates and final dates for payment. It's got particular relevance for contract drafters. And lastly, we return to Scots law for the topic of prescription, and we consider when claims for breach of contract or DLIC in a construction project will be lost by passage of time. We have a new Prescription Scotland Act 2010, but the only problem is it's not yet enforced yet and quite likely won't be enforced for another 3 or 4 years. Accordingly, we need to pay attention to Erica's update on the current state of this complex area of the law. She'll tell us what she knows about the WPH Development case, which is going through the courts just now and probably being heard next March. I was also asked to comment what stands out for me this year, and I cannot but mention the Van Oord against Dragadas case and the decision which concerned the omission of work from Van Oord's subcontract and the transfer of it to other parties in breach of contract. The financial consequences of that are what's an issue, and the Scottish Appeal Court should hear that case in the spring next year. So we're making the law in the Scottish courts, and we'll maybe cover that next year. And with that, I'm going to hand over to Kirstin.
Thanks, Chris. So, as Chris said, I'm going to kick things off today by looking at the case of Energy Works Hull against MW High-Tech Projects, which is a 2020 decision from the TCC. So, in 2015, Energy Works appointed MW High-Tech as its main contractor for the design, construction and commissioning of an energy from waste plant. Now, this isn't the first time this project has ended up going through the courts or even been discussed on our winter webinar series this year. If you joined us last week, you would have heard Andrew Little discuss the dispute between MW and one of their other subcontractors and whether or not the works amounted to construction operations. The decision that I'm talking about today is also in respect of a preliminary point of a much wider dispute worth around £180 million. So it seems like this is going to be a particularly litigious project. Next slide, Chris. So following some significant delays to the project, the employer terminated the main contract for a contractor event of default, and that was the delays to the completion of the works. Perhaps unsurprisingly, the contractor argued it was entitled to an extension of time, and therefore the employer hadn't been entitled to terminate the contract. Whilst we're still awaiting a decision on that element of the dispute, the preliminary decision focuses on the liability of one of MW's subcontractors for these delays. Next slide, Chris. So the contractor argues that in the event they're found to have any liability to the employer for defects or delays to the works, they should be able to pass those liabilities on to their subcontractor. However, the critical point here is that the contractor had assigned the subcontract to the employer following the termination, as had been required under the main contract. The contractor now finds itself in a very tricky position. It's assigned the subcontract, so how does it pass this claim down when its rights under the contract have been transferred to the employer? The subcontractor argued that the assignment meant it should have no liability to the contractor. In response, the contractor argued that the assignment of the subcontract was an assignment of future rights only. Or, in the alternative, if past and accrued rights had also been assigned, the contractor could claim a contribution from the subcontractor. Next slide, Chris. So I'm going to ignore the question of contribution for the purposes of today. But in effect, there were two critical questions before the court. What is the effect of the assignment of the subcontract on rights accrued prior to the assignment, i.e. did the assignment only assign the future right to performance? And in the alternative, if the assignment transferred accrued rights as well as future rights, did it also transfer past and future liabilities and obligations? So in effect, was the assignment really a novation? As I said, I'm not going to talk about the question of contribution or the court's findings on that matter today, and that's because they're pretty complicated, and it's one of those areas where the law in Scotland and England is fairly different. But the key message here is that seeking a contribution from someone as opposed to having a direct contractual right will offer you a limited set of redress. Next slide, Chris. So in considering whether both accrued and future rights had been assigned, the TCC emphasised the use of the expression assign the subcontract in the main contract. They took that term to mean the assignment of accrued and future rights. Whilst the court noted that it would be possible to limit an assignment to future rights, they'd said that that would only be possible where there was clear wording to that effect in the assignment. The assignment did not transfer the obligations under the subcontract and did not take effect as a novation. It was purely an assignment of rights. Next slide. So what lessons can we take away from this? If you want to only assign future rights, you need to make that clear in the wording of your assignation or your assignment. If you want to transfer obligations as well as rights, you should consider if you want to use a novation agreement as opposed to an assignation. That will require a tripartite agreement as opposed to just a notice though, and you should think about whether or not it then requires more documentations in terms of post-novation warranties back to your original contracting party. The provisions requiring the assignment of subcontract on termination of default are common within the construction industry, and it's difficult to distinguish the wording in this case with the wording which is used in the SBCC, GCT or NEC forms of contract. These provisions are, on the face of it, beneficial to an employer, and there's no reasonableness test attached to requests to assign, such as there are in the FIDIC suite of contracts. However, our experience is that these requests aren't commonly made in practice. So on that basis, you might want to consider if you should amend them so that they either only cover accrued rights or by simply deleting the requirement altogether. New slide, Chris. So what's also significant here is that the employer in this case had been granted a collateral warranty from a subcontractor. That would be probably what we would all say pretty standard practice. And as would be standard practice, that collateral warranty contains step-in rights in favour of the employer. Yet the employer chose to rely on the requirement to assign the subcontract as opposed to exercising their step-in rights. From a commercial perspective, step-in rights might be able to provide a balance between the employer's interest in continuing a subcontract on termination of the main contract and the contractor's concerns regarding the issues of assignation of the subcontract arising from this case. The decision might also lead to an increase in non-assignment clauses being included in subcontracts. The clause in this contract and in the standard forms provide that assignation is only insofar as the contractor is legally able to do so. So if the subcontract prevents assignation, that could address the issue without the contractor having to raise a potentially difficult issue with the employer. What's clear from the decision is that assignment provisions such as those in this case represent a significant exposure to main contractors in the event of termination for default. The contractor here, as I say, is in a very tricky position. Because of their assignment, they've got no right to pursue their subcontractor, and there's only limited scope for getting any sort of money from them through seeking a contribution. And finally, I'd just say watch this space, because I think there will be another few instalments of this saga yet to come. And with that, I will hand over to Chris Horsley.
I'm going to cover the latest position on good faith, as highlighted by the Rockrose case, which concerns some corporate cloak and dagger on the high seas. Now, a breach of good faith is one of those criticisms which is often mounted in proceedings by one party to seek to emphasise their argument that the other party has failed to act in the spirit of the relevant agreement. The key question in Rockrose was whether an express term of a contract implemented detrimentally to one party should be qualified by a good faith requirements to impose limits on how it is used by the other parties. Next slide, please. The good faith argument is often cited in cases where the straight reading of the relevant contractual provisions is not particularly persuasive in support of a party's argument. Where Party A considers that the behaviour of Party B falls out with its reasonable actions on the basis of the wording, a good faith breach could be claimed, particularly where this is supported by wider knowledge of the business venture and the relationship between those parties. If the contract is not explicit about there being a good faith obligation, the claimant may nevertheless assert breach of an implied term to behave in such a manner. So next, a quick recap on implied terms. So there's a requirement that any implied term must be obvious, and that question is determined by what's called the officious bystander test, which is to say that if we, as neutral bystanders, were back at the time of signature of the agreement, before any disagreement, and we were to ask both parties whether this was their expectation about the point which is now being suggested as an implied term, both would answer, yes, of course, that's what we meant. And the term also must be necessary in terms of carrying out the business of the contract. A term which is just extra ballast rather than truly pertinent will not be implied into the contract. So next, let's look at where we stand on good faith. Case law has previously summarized this as an obligation to observe reasonable commercial standards of fair dealing. We start from the position that there is no overall legal requirement that parties to a contract must act in good faith to each other. It has been established that regardless of whether a good faith term is expressed or argued to be implied, that term should not cut across other expressed terms of the agreement, and there are limits to what such a term could require of a party to do. The Liverpool FC case in 2019 is one example, and in that case showed that a party can issue very stretching estimates in relation to a contract without breaching a good faith obligation to the other party. Case law has also confirmed that a greater degree of communication and cooperation is expected between parties to longer-term contracts, making it more likely that good faith will be implied. So next, let's look at the Rockrose case itself. The Rockrose case concerns a four-party joint venture to extract oil and gas in the North Sea. Rockrose acquired the share capital of one of those four parties, which was the operator of the project, and had fully discussed its intentions to invest and take the project forward with those other parties as part of the takeover process. Unfortunately, one of the other joint venture members was very displeased about this because they had been unsuccessful in their own bid to take over that operator. Then, despite being fully aware of Rockrose's efforts and expenditure, that unhappy party managed to persuade two of the other joint venture members to terminate Rockrose's appointment as operator, following which that unhappy party took over the operator role. The agreement between the four parties had express terms about such a termination, so there were questions about interpretation in relation to those terms and also an argument that such terms should be qualified by an obligation to act in good faith. On the next slide, you can see the most relevant express term on the screen, and that effectively allows three of the four joint venture members to agree to terminate the operator, and the vote of that operator is ignored in any such a decision. This term was held to be clear and unambiguous. A strict interpretation would therefore allow the joint venture members to terminate Rockrose. On the next slide, we see that despite the question of the express term being clearly answered, The question was then, was Rockrose going to be saved by an implied term of good faith, given the morally questionable application of the contract by the other JV members? Each side argued their case, and for Rockrose, they focused on the longer-term nature of the partnership contract, as was case law pertaining to concepts such as the limits on behaviour of a decision-maker in such cases. For other joint venture members, their argument was clearly defined by the express term. They argued that that was agreed between commercial parties, it was absolute, and leaves no room for an implied term to be added for the contract to work. So what was the answer? Well, the next slide shows that the court held that those joint venture members got their way. It was held that adding an implied term would be an unwarranted interference in the freedom of the parties to contract on terms which they chose. To add more reasoning, the next slide shows that, addressing Rockrose's arguments, the court specifically noted that despite the contract being of longer-term nature and based on cooperation between those parties, this particular term was express and unqualified, and that meant that implying a term was not necessary in order to allow the contract to operate correctly. So what lessons can we take out of this? On the next slide, we show that one is application of a duty to act in good faith is entirely dependent on context, and context will change on a case-by-case basis, rendering this area of law a difficult one to predict in terms of dispute analysis. The court may well allow a party to behave badly if their contract clearly allows it to do so, but the court retains discretion to draw a line if it considers that the contract allows them to do so in that case. To counter this, note that parties are open to either excluding or defining the duty, and in careful drafting, they can manage the uncertainty and minimize that risk. Drafting in foresight of a potential issue is key. Parties need to work harder before signature to state expectations clearly. Few of us have a crystal ball, so this is yet another area of disputes where the paper trail of communications may be critical to supplement the contractual terms. In addition, parties should remember that a good faith term may be implied where it is not express, notably in a long-term contract which relies on collaboration. And with that, I'll hand over to Richard to tackle the next of our cases.
Thank you. Thank you. Next slide. When pursuing or defending a claim, the exclusion and limitation clause will often significantly impact on the outcome. Next slide. For that reason, the terms of an exclusion clause should be carefully considered at the time of entering into a contract and when weighing up risk as the contract proceeds. They often provide an important element of comfort in risk assessments for a working assumption that we can never be liable for more than X million pounds or for particular types of loss. But in weighing up the reality of risk, it's important to remember that clauses which exclude liability will be interpreted strictly by the courts. The precise wording of such clauses is important, as will become apparent in the case I'm about to discuss. And the term consequential and indirect loss is a regular formula used in exclusion and limitation clauses, but it's important to understand what the courts will take that phrase to mean. Next slide. Consequential indirect loss has been taken to refer to the second limb of Hadley v. Baxendale, an old case which many or most of you will have heard of and be familiar with. Whilst I'm going to discuss a case which is a bit more recent, Hadley is an important English case, dates back to 1854, and it's all about the broken crankshaft of a mill steam engine, lost profits arising from late delivery of the broken crankshaft were not allowed on a test of foreseeability. This has given rise to a twofold test at common law for the recovery of damages. Limb 1 relates to direct losses, which naturally arise from the breach and they're more easily recoverable. Limb 2 relates to indirect or consequential losses, for which there's an additional test of foreseeability. They can be recovered if they were contemplated by the parties at the time the contract was formed. Hadley's about remoteness. It's when a loss is so remote that no one would reasonably have expected it to be recoverable. And it's about common law damages, in other words, the general rules for recovery of damages. But where parties refer in their contract to excluding consequential or indirect losses, this is generally taken by the courts to be a reference to the second limb. Next slide, please. The issue of the importance of language is well illustrated in the English Technology and Construction Court decision in April 2020. Sony stored £40 million worth of DVDs for 2E, a subsidiary of the BBC, in a warehouse. The warehouse was burnt down in the London riots of 2011. Questions arose regarding Sony's duties as a warehouseman for security and fire protection. We don't need to trouble ourselves with questions of liability here. We just need to know that Sony was held to be in breach of the relevant obligations, and 2E were compensated for the value of the lost stock. But were they liable for lost profits and for business interruption? Next slide. Next slide. Oh, that's it. The contract had an exclusion clause, and you'll see that it included the indirect and consequential loss formula. It also had express references to loss of profit, loss of profit and business interruption. Sony felt that they were covered by the exclusion clause. Loss of profits could not be recovered. And this is just the sort of clause which gives some comfort when faced with a loss of profits claim. Next slide. So were Sony right? While I'm talking to this slide, you can type Sony or 2E into the comments chat to reveal which side of the coin, which side you come down on. Sony argued loss of profits were excluded and could not be recovered. Loss of profit is a claim for consequential loss. Anyway, the other clause 10.1 expressly referred to direct losses being the manufacturing replacement cost. 2E argued that it could recover loss of profits because indirect and consequential loss is the same as the second limb of Hadley, so it's a question of foreseeability and reasonable contemplation. Business interruption and loss of profit arose directly from the fire. It was therefore not consequential at all. Any punts at the right answer, Sony or 2E? The answer is 2E's argument was preferred. Yes, loss of profits could be recovered and the exclusion clause didn't prevent that. The court interpreted what the words said, but they said that the contract was unhappily drafted. Because loss of profits and business interruption were not standalone, they were linked to indirect and consequential loss. They still had to meet the Hadley Limb 2 test. So it was open to the court to decide that a loss of profit could be a direct consequence of the fire and not indirect at all. The issue arose because the courts tend to anchor the commonly used phrase consequential indirect loss to Hadley Limb 2. I should say that when you look at the case law as a whole, it comes in with mixed results. This orthodox view of the linkage with Hadley is not always shared and is quite controversial. And I understand that the Sony case, Sony is seeking leave to appeal. So what are the lessons? When you choose the words indirect and consequential loss, then applying the orthodox approach of the courts, you are selecting the rules of Hadley Limb 2. Hadley Limb 2 leaves it open to the court to decide whether a loss is in fact direct, a natural consequence of the breach, or whether the loss was foreseeable at the time of entering into the contract. You may have your own conceptions that types of loss, such as loss of profits, are always indirect, but that may not necessarily be so. So the phrase indirect and consequential loss is not a complete get out of jail card for anything other than the most direct losses. It still allows the lawyers to argue what types of loss, whether types of loss are properly direct, including loss of profits, and what was actually contemplated on the facts. And there may also, that other clauses in the contract may also be relevant to that interpretation. An absolute exclusion of loss of profit or business interruption might make it clearer. The difficulty for Sony was that they linked loss of profit to indirect and consequential loss. I'll now hand over to Kate.
Okay, thanks, Richard. So today I'm going to talk about the consequences of a recent TCC decision, Rochford Construction Limited versus Kilhan Construction Limited. And in particular, I'm going to pose the question, in a construction contract, can the final date for payment be linked to receipt of a VAT invoice? Okay, next slide, please. So just a quick reminder, the Housing Grant Construction and Regeneration Act 1996, otherwise known as the Construction Act, states that every construction contract shall provide an adequate mechanism for determining what payments become due and when. and also provide a final date for payment in relation to any sum which becomes due. The parties are free to agree how long the period is to be between the date on which a sum becomes due and the final date for payment of that sum. So if the paying party doesn't pay by the final date for payment and doesn't serve a pay less notice, then the amount due becomes the notified sum and must be paid. The unpaid party can adjudicate for payment and may also have a statutory right to suspend performance under the construction contract. If parties don't include adequate payment provisions, these are implied into the contract by virtue of the scheme for construction contracts. Next slide, please, Chris. So in practice, we quite often see the final date for payment in a construction contract not being a set date, but instead being linked to the issue of a VAT invoice. For example, the final date for payment will be a particular number of days following receipt by the payer of a VAT invoice. And that's what I'm looking at today, specifically in relation to the case Rochford versus Kilhan. So I've just put a bit of a timeline there on the slide, just to paint the picture. So in August 2018, Rochford, the contractor, and Kilhan, the subcontractor, entered into a subcontract for the construction of reinforced concrete frame at Richmond upon Thames College. In May 2019, the subcontractor Kilhan submitted an interim payment application with a value of around £1.4 million, and that related to the period ending 30th of April 2019. We'll call that interim application 9. And then in October 2019, the contractor, Rochford, issued a payment notice certifying a sum of around £1.2 million. So that's payment notice 9. A dispute then arose between the parties. Was the payment notice late? So this went to adjudication, and the adjudicator decided that the due date was the 20th of May 2019. So that was the date that interim application 9 was submitted by the subcontractor. And the final date for payment was 30 days later. Therefore, as the contractor hadn't served its payment notice or a pay less notice within the required timescales, then the sum claimed by the subcontractor in interim application 9 was a sum due, and it became the default payment notice. So the subcontractor raised proceedings to enforce the adjudicator's decision, and the contractor challenged this. So next slide, please, Chris. So just to have a look at the specific payment terms in the contract. So I've put an extract on the slides here from the contract, and you'll see there's reference to the application date being the end of the month and payment terms being 30 days from invoice as per the attached payment schedule. So the contractor claimed that based on the terms of the contract, the adjudicator's decision was wrong. First of all, the application for payment should have been made at the end of the month, so should have been made on the 30th of April 2019, which it wasn't. And also the final date for payment was to be 30 days from receipt of an invoice. And as the subcontractor hadn't submitted an invoice until October 2019, the contractor claimed its payment notice was issued within the period allowed. So next slide, please, Chris. So what did the court decide was the due date and what was the final date for payment? So in terms of the due date, first of all, the court held that the phrase application date end of month in the contract was unclear and ambiguous, particularly in this case, given there was no payment schedule actually included despite being referred to in the contract. So there was no date specified for interim applications and VAT invoices, etc. Additionally, this was interim application 9, so the parties' own dealings up to this point didn't require the previous payment applications to be submitted on the last day of the month, as all previous 8 interim applications had been submitted at a later date. Also, just the wording was generally unclear. Did they mean the last business day of the month or the final calendar day of the month? Again, it just wasn't clear. So the scheme applied, and the court held that the due date was the date that the subcontractor Kilhan made its claim. So same conclusion reached by the adjudicator. In terms of the final date for payment, the court said it wasn't clear when the invoice should have been issued, and pegging the final date for payment to service of an invoice was impractical. The judge stated that the final date for payment must be pegged to the due date and be a set period of time, not an event or mechanism such as the issue of an invoice. So the court found in favour of the subcontractor Kilhan. The payment application was submitted on time and the contractor didn't issue its payment notice or pay less notice within the required time period. Next slide, please, Chris. So just going back to the original question, in a construction contract, can the final date for payment be linked to receipt of a VAT invoice? The short answer is no, that's likely to be non-compliant with the Construction Act, and it's likely adjudicators will apply the scheme in light of this decision. I would flag that the point relating to linking the final dates for payment to VAT invoices was obiter, it was specifically stated that this conclusion was reached with some diffidence, so it may be that this is challenged in subsequent proceedings. Next slide, please, Chris. So clearly this could have a potentially significant impact. As mentioned, we quite often see contracts specifically linking final dates for payment to the provision of a VAT invoice. That's largely driven by a company's accounting policies and software built around invoicing, etc. However, following this case, it's clear that construction contracts containing these provisions may now be subject to challenge and the scheme is likely to apply. The statutory payment period in the scheme is often shorter than the contractual period the parties had agreed, which in turn will result in a failure by payers to submit pay less notices within the required timescales, and we might see a potential increase in smash and grab adjudications. So parties need to be aware when entering into a construction contract, you need to ensure that the final date for payment is a set number of days after the due date. However, an option is to link the due date for payment to receipt of an invoice rather than the final date for payment being linked to receipt of an invoice. This would effectively allow the parties to have an invoice as part of the payment process, whilst ensuring the contractual payment provisions remain compliant with the Construction Act. I would also flag in response to this case, the NEC have already issued amendments to payment provisions in the NEC suite of contracts that link the final date for payment with the submission of VAT invoices. So for example, the professional services contract. So we're already seeing the industry reacting to this case. I'll hand over to Erica just now to talk about prescription.
Thanks very much, Kate. So for those of you who attended last year's seminar series, you'll have heard my 2019 doom and gloom update on the law of prescription. Next slide, Chris. For those of you who haven't already heard my frightening tale of how the law of time bar has developed since 2014 and the ICL Plastics case, the very short version of the story is that even in a case of latent defects, a pursuer might find that its case is time barred before it has even become aware of an issue. The clock starts to tick when there is a concurrence of the breach of contract or negligent act and the loss, which is also known as the damnum. The Supreme Court of the United Kingdom and the Court of Session in Edinburgh have both held that a pursuer must utilise the benefit of hindsight in order to objectively realise when it has suffered a wrong which has resulted in a loss. If 5 years have passed since the wrong occurred and the loss was incurred, then the claim is barred forevermore. The courts have held that in the event of negligent design resulting in developments being built, the prescription clock starts to tick the moment a penny is spent building out the design, because that is when, with the benefit of hindsight, there was a loss. This has been held to be the case even if it was simply not possible to recognise that there was anything wrong with the design until years after PC, which could, as many people will know, only be when the first cracks start to appear or when people start to fall ill from leaking gases. Once that clock starts to tick, as I've said, a pursuer only has 5 years to commence legal proceedings. Practically every time I explain this concept to anyone who is not a geeky construction lawyer, I am generally met with disbelief. Next slide, Chris. But there are now 2 cases pending before the Scottish Appeal Court in relation to this issue. The first is Loreto Housing, and I talked about that case last year, so I won't cover the ground again, except to note that the appeal has still not been yet heard, although as Chris mentioned, it might be March for that coming up. However, we also have an appeal from Glasgow Sheriff Court, and this case is particularly relevant to the issue of latent defects. In April, Sheriff Reid issued a judgment in the case of WPH Developments against Young and Gold LLP in liquidation. The case is a mix of property and construction. Can I get the next slide, Chris? It involves an architect who made an error in relation to the location of the outer boundary of a developer's site. The developer, using the erroneous plans, paid contractors to build a housing development, but some of the outer boundary walls encroached onto land owned by others. The question before the court was if the designs were drawn up and the money was spent on the contractor's work to build the walls more than 5 years before a court action was raised, had the action against the architect prescribed. The developer was seeking to recover the costs of, amongst other things, demolishing and relocating boundary walls, but also in reaching financial settlement with the landowners who were affected by the issue, the keeper having bounced applications from various purchasers to register their titles. Next slide, please. Based on the case law of Gordon's trustees and Midlothian, the architect advanced 2 propositions. Firstly, the loss occurred as a matter of objective fact as soon as the developer, in reliance upon the erroneous plans, incurred expenditure to contractors building upon land it did not own, because the expense in doing so was thereby wasted. And secondly, that the developer was fully aware that it was incurring expense, albeit only in hindsight known to have been wasted, and therefore cannot rely on Section 11.3 of the 1973 Act to postpone the date of commencement of the prescriptive period. The Sheriff held that the first proposition is correct, but that the second proposition is wrong. He examined the role of hindsight following the chain of case law since ICL Plastics and determined that hindsight should only be applied to identifying the date of the occurrence of the loss, but not the date when a party becomes aware of the loss. He stressed that these are 2 different concepts. And next slides. Injecting what I would say is common sense to the matter, Sheriff Reid opined, hindsight is properly applied to determine the former, the date of occurrence of damnum under Section 11.1 of the 1973 Act, but it has no part to play in determining the latter, the creditor's awareness of the occurrence of that damnum under Section 11.3. To apply hindsight to establish a creditor's actual or constructive knowledge at a point in time is conceptually illogical. Besides, in essence, Section 11.3 is concerned with cases of latent damage. If hindsight is to be applied to establish whether a creditor was aware of the occurrence of damnum, no damnum could ever be truly latent. Section 11.3 would thereby be rendered redundant. He goes on to say Midlothian, with respect, was wrongly decided. I think this is the Shrivel equivalent of a mic drop, although I suppose it somewhat loses its effect when a mic drop is open to appeal. An appeal the architect has. Next slide, please. Permission has been granted for the appeal to be heard by the Inner House of the Court of Session, with the court granting the appeal noting that there are now irreconcilable judgments in the Court of Session and in the Sheriff Court on this important area of the law. If this court were to uphold the Sheriff's decision, that position would remain. That would be unsatisfactory. It would place solicitors and counsel in Scotland advising on prescription in an even more difficult and uncertain position than that which already pertains in relation to this difficult area of the law. I flag this section of the decision mainly to reassure everyone listening that when you are struggling to understand the current law of prescription, well, so are the courts. Next slide. I end by noting that the Prescription Scotland Act 2018 might be very slowly riding to the rescue. It is due to change the law and say that the 5-year prescriptive period will not start to run until a much later date. This is very good news for all those who have a claim to pursue. The Act was passed in 2018, but it is not yet in force. The current position is that the Scottish Government is consulting on draft commencement regulations. It is currently proposed that there is a period of 3 years between the commencement regulations being made and the substantive provisions of the Act coming into force. As a firm, we've responded to this consultation and noted our concerns in relation to the delay on this. But if the regulations are not tweaked, we think it might be 2024 before we can rely on the new Act. Secondly, Sheriff Reid has expressed concern that in his view, the new formula, which for those interested is found in Section 5 of the 2018 Act, is not sufficient to change the Midlothian argument. His view is that if he was hearing the WPH case with the new wording from the 2018 Act in front of him, it would still have been open for counsel for the architect to advance the two propositions that they did. He still thinks those propositions would be wrong, or one of them at least, but there is nothing in the new Act that would extinguish them. I'm therefore hoping that we have some further guidance from the Inner House Appeal Court in short course, which, as mentioned already, may well be in March 2021. Back to you, Chris.
Thanks, Erica. So we've heard 5 cases, so just 5 quick takeaways, one from each case. So taking the first case, be very clear when raising or defending any action what the impact of any assignation or innovation may have on that court action. In terms of the second case, in implied terms of good faith, it's clear that you can't rely on the court implying a term. If a term is important, you need to write it into the contract. Thirdly, in terms of indirect and consequential loss, you always need to consider what losses might be recovered in any breach scenario and draft as best you can to make it clear what losses are being included and what losses are specifically being excluded. In terms of payment and VAT invoices, the clear message is don't link the final date for payment to an invoice, but rather peg it by a set period of time to the due date. And in terms of prescription, it's clear from what Erica said, it's almost never too early to raise an action as the law stands, so go for it. So it's now time for the Q&A, and we've got a couple of questions, but do keep other ones coming in if anyone's got other questions. The first question is for Kate. Kate, is it okay to link the due date as opposed to the final date for payment with receipt of a VAT invoice?
So yes, it is okay in terms of compliance with the Construction Act, and it's absolutely okay to link the due date for payment to receipt of a VAT invoice. However, practically there could be some issues with not having fixed due dates. So, for example, it might be preferable from a risk management perspective to have sort of set due dates each month rather than a date that's subject to change depending on when a VAT invoice is received. And just to ensure that parties know when payment notices, pay less notices, etc. need to be issued.
Thanks very much, Kate. And Richard, a question for you. Would it help to specify particular types of losses which are to be excluded in an exclusion clause?
The answer is yes. The problem in the 2E case was the linkage to indirect and consequential loss, and that takes you down. All particular types of losses you intend to exclude, loss of profits, interruption of business, etc., as separate issues, that should make it more robust.
Thanks. I think we've got most of that. I think that's all the questions we've got at the minute. Well, thanks everyone for attending. Certainly, if you've got other questions, please feel to email them to the presenters or myself. A recording of the session has been made today and it'll be issued tomorrow to all attendees. So thanks very much and enjoy your afternoon.